Any mention? Fine. So we'll see you in single bench.
Any mention?
Please, Your Lordship. Lordship, I beg to make a mention on item 6.
7.
7 is connected matter, Your Lordship. It's a 2019 matter.
These are
Service matter? No, Your Lordship.
no, Your Lordship. This is eviction. For that forest colony.
Oh,
case,
that
Your
forest colony.
Lordship, yes.
Oh, okay. Why are we delaying this matter? Lordship, can you grant 2 weeks compensation, Your Lordship? 2 weeks, Your Lordship. You have been ousted.
No, Your Lordship. They are still in possession.
Interim order is there?
There is no interim order, Your Lordship.
Then what have they come for?
They have challenged that notice of eviction, Your Lordship. Because the government wanted to resume the land.
There is no stay order.
There is no stay, Your
Then you
Lordship.
have
But still, government does not improve their stay, Your Lordship.
So complicity is there then.
If the matter adjourned, may I pray, Your Lordship, if the matter can be taken up on 23rd after election. Or that is April.
3 weeks.
On 23rd, Your Lordship. April is that side, Your
You want a fixed date? You want a fixed date?
Lordship, yes. If
If
it
it is a
can,
fixed date, it has to be heard on that day. On premier by parties seeking accommodation,
I'm not praying for adjournment, Your Lordship.
premier by petitioner
Lordship, yes.
seeking accommodation, the same not be objected to by the state respondent. Matter is adjourned. This is matter on 23.
Lordship. Apply, Your Lordship.
Please, Your Lordship. Your Lordship, I beg to mention item number 11. Mr. Hazarika is on the other side. It's for the petitioner and for the private respondents. The matter can be taken up after.
My friend is taking all the time, so one time may be granted.
What is this case about?
This
For
Nokma.
Nokma. Dispute of Nokma.
will take some time.
My friend may make.
No, you have come against the order of the CEM
Lordship.
on premier by the respondent number.
Private respondents. Number 4, Lordship.
Number 4, seeking accommodation. Same not be objected to by petitioner, matter is adjourned. This is same after 2 weeks.
Obliged.
Please, Your Lordship, I beg to mention item 12. I'm praying that this matter may come after 2 weeks.
What's what he has said?
No objection, madam.
On premier by the petitioner seeking accommodation. The same not be objected to by state respondent, matter is adjourned. This is same after 2 weeks.
Lordship, similar prayer for item 13.
These are connected.
No, Your Lordship.
Kaju, same order.
Lordship, I beg to mention item number 14. Lordship, I humbly pray the matter can come up after 2 weeks. My Lord. The conducting counsel, Mr. Pinongbri, is indisposed, my Lord. So kindly have the matter after 2 weeks.
On premier by. Katu kajai. Jo mo. Kum papi ai tu ni tawon. 2 weeks then.
Highly obliged, my Lord.
Supplementary list, item number 1.
Item number 2, supplementary, please,
Yeah.
my lord.
Tell me.
May it please your lordship. I, the counsel, on behalf of the petitioner, Your Honor, in this instant bail application. The petitioner is Samsul Haq Chowdhury, who is the father of the accused person in this instant case, Your Lordship. The brief fact of the case, my lord, that accused person, Masoom Ahmed Chowdhury, in this instant case, was kidnapped by the 6 miscreants, Your Lordship. And while kidnapping, my lord, the police could arrest all the miscreants. And during the course of investigation, as per the allegation by the investigating agency, my lord, that even the person who has been kidnapped also involved in this case as charged and framed under section of the NDPS Act, my lord. My lord, that in the previous 3 bail application have been preferred before this honorable court, my lord, and where this honorable court find it deemed fit to reject on different ground, my lord, as I would like to refer to the page number 8, para number 9, my lord. But where the first bail application was rejected on the ground that the prima facie on merit, it seems that alleged contraband substance were recovered from the accused person, that he also has a nexus with the other co-accused person said to be involved in the case of kidnapping, as well in the case of drug possession of peddling him. Second, my lord, was dismissed as withdrawn. And the third, that was on the 8th of December 2023, holding that prima facie a case has been made out against the accused person as far as his involvement in the case of drug peddling of trafficking is concerned, my lord. However, my lord, that the changes of circumstances between the time when the last occasion of the bail until date, Your Honor, my lord, that in the recent few months back, on the 19th of January, the concerned trial court has released the co-accused in this instant case on bail, my lord. And even all those co-accused who have been involved in this case has been released on bail, my lord. So the same contention I have been preferred before the concerned trial court, but it was rejected on the ground that because I'm not from the local, I'm not from the district, that is the sole ground for reject by the concerned.
Have you annexed that order?
Yes, my lord.
Where is it?
Annexure 4B, page number 61, my lord.
Where's the observation that your bail was rejected only on that ground?
On a ground, yes, my lord. Annexure VJ, my lord, 5J, page 98. 5J, page number 98, my lord. The last 99, in the page number 99, my lord, accused Masoom Ahmed Chowdhury is not a resident of Meghalaya, and there is a possibility that he may abscond. At a trial has commenced, and evidence of 4 prosecution witnesses have already been recorded, my lord.
Yes, Mr. Shulai.
May it please your lordship.
I think this ground is not justified.
Lordship, that is not that order has been not wrongly. Lordship, kindly come to that page 99.
Yes.
Lordship, because already that portion has been read, your lordship. Lordship, kindly see the finding of the learned trial court. heard both counsel. Lordship is there
Yes.
with me. Heard both counsel representing the parties, and I have also perused the application filed by the petitioner. The detailed discussion as to why bail for the accused cannot be considered in this case was made in the order dated 31/1/2024. Lordship, kindly see that order of 31/1/24 at page 85, Your Lordship. Then, Lordship, kindly come to the observation to the finding of the learned trial court at page 96. Page 96, Your Lordship. Lordship is with me.
Yes.
Having heard submission of both learned counsel representing the parties on careful perusal of the record, it is evident that against the bail order passed by this court, and on earlier occasion, appeal was preferred before the Honorable High Court of Meghalaya on 3 occasions. On perusal of the last order passed on so and so, it is seen that Lordship, after hearing parties at length, has come to the conclusion that prima facie case has been made out against the accused person as far as his involvement in the case of drug peddling or trafficking is concerned. The said bail application was rejected after the appellate court has considered the overall facts and circumstances of the case. No doubt the learned counsel for the petitioner has pointed out many flaws or procedural lapses during the investigation process, as procedure as laid down under the NDPS Act was, as pointed out, was not complied with. However, as the case has already been proceeded for evidence, it will not be safe for this court to decide it now. Even the Honorable High Court order has discussed about the fact of the case and evidences of the examined witnesses. Lordship, this is a clear finding, Your Lordship. Learned trial court has discussed the case on merit, taking into account the observation made by this honorable court in the earlier order. Your Lordship, kindly come to page
See,
101.
Mr. Sulai, you know very well. You see, if an order is passed by a superior court, even the High Court, it is based on particular facts and circumstances of the case. More often than not, though it may not be, very often it is not to be, to be pointed out, but it is implied that the merits have not been gone into, number one, and number two is the trial court is not to be influenced by the observation made by the High Court. It has to base its its order on its own observation and deduction. So anyway, that's beside the point.
Lordship, then 99, Lordship, kindly come to page 99. So far that finding that it's not resident, Your Lordship, of Meghalaya, this is only an observation of the trial court, Your Lordship. It's only an observation. Then, Lordship, kindly come to page 103, Your Lordship.
What is the amount involved?
15.01 gram.
It's intermediate quantity, Your Lordship.
Intermediate.
15 point
I've
something.
been more than
How long have you been in custody?
more than 1 year, 1 year and 2 months. And all co-accused, my lord, has been released on bail. And those co-accused who kidnapped me has been already released on bail. I'm the only one now. 6 of them have been released on bail.
No, there another one is there, Your Lordship. There is a finding that one person, he could not furnish the surety, is still in jail.
Furnish surety, my lord, that is it. Now they already furnish.
How many witnesses are there?
10 witnesses. Out of 10, Your Lordship, 4 had already been examined and cross-examined. So, Your Lordship, hopefully the trial will be over very soon. Lordship, in this case, Your Lordship, in this present bail application, this is the 4th bail application, Your Lordship. The main contention of the accused is that non-compliance of section 42 and 50, Your Lordship. These contentions cannot be gone through, Your Lordship, at the stage of bail, Your Lordship.
Those are issues of merit.
And that is to be seen by the trial court, Your Lordship. He's a drug peddler, Your Lordship. That finding, Your Lordship, by this honorable court can be seen at page 107, Your Lordship, at paragraph 7 of the early order.
See, that is an observation on prima facie.
Lordship, yes. Lordship, yes.
but-
And the trial, plus the trial now is going on, Your
So
Lordship.
the trial will, you see, will prove whether he is or.
He is involved or not, Your Lordship, yes.
Yes, yes,
That's true, Your Lordship.
Yes, my lord. Now, the question of the angle of a peddler, it is all under the settlement procuring by the investigating agency from the co-accused. You all know that we may not fail to, I think in the case, since that is not my contention here, my contention is parity, on the parity and the non-compliance. Since Learned Counsel has already brought that, my lord.
Do you have any authority to support your case?
Sorry?
Do you have any authority to support your case?
Yes, yes. How the procure, they were using the police investigation using third degree. Even an action has been taken by the court for using force while during the course of investigation, my lord.
Then, Lordship, kindly come to page 103, Your Lordship, at paragraph 8. These are my prima facie finding on merits, Your Lordship. 103, Your Lordship, para A. On consideration of the submission made, what is to be noted here is that the case has been charge sheeted, and as such, the submission of the petition on behalf of the said accused son is to be based on merit. Prima facie on merits, it is seen that the alleged contraband substance was recovered from the accused son of the petitioner, and that he also nexus with the co-accused person said to be involved in the case of kidnapping as well as in the case of drug possession or peddling. They are finding prima facie finding on merits very clear, Your Lordship.
See, when the trial has commenced,
Lordship, yes.
evidence is being recorded.
Four witnesses had already been recorded. Lordship, the remaining 6, hopefully it will be done, it will be over soon.
My lord, that 1 year is already lapsed, and only 4. If he give with the natural calculation, or would will take another 1 or 2 years, there is no possibility. There is no possibility, a likelihood that we will conclude the trial within the time, my lord. And since Learned Counsel has already mentioned, my lord, that the contraband, illicit contraband, was not seized from me. It is all there in evidence in the case record, was seized from the vehicle which not belong to me. And if just because my presence was there in the vehicle, then I'm in detaining and my incarceration has been prolonged, my lord, then the co-accused who have been the owner of the vehicle and who led them, the police agency, to search the vehicle, have already released on bail. So what is the question is whether I'm reasonable to be detained further just because I'm not from the local, my lord. And
Yes, I think what Mr. Counsel for the petitioner was submitted that the petitioner is a father of the accused person named Muhammad Masoom Ahmed Chaudhry, was arrested in connection with what is the case number?
Clear PS case number 10-02-2023.
Clear PS case number 10/2/2023 under section 364A capital A /34 IPC, read with section 21B small b NDPS Act under bracket B. The case on investigation being completed, the charge sheet has been filed, and the son of the petitioner along with other co-accused have been forwarded to the competent court of jurisdiction for to stand trial, wherein the case being criminal NDPS case number 2 of 2023 was registered. The stage of the case at present is that 4 out of 10 witnesses have been examined. 4 out of 10 prosecution witnesses have been examined. The learned counsel for the petitioner has submitted that it is a fact that that 3 bail applications have been moved on behalf of the said accused person mentioned above, and were rejected on the grounds specified therein. However, since the order passed in the last bail application, dated, when was the last order passed? Eight 2023. Correct me if I'm wrong.
8/12/2023, madam.
Fresh circumstances have arisen, inasmuch as in the meantime 6 co-accused. Is it 6?
6. 4. There is a complication in this case because only 3 accused has been charged under NDPS. The co-accused has been charged under session case 364A. So those 4
But charges, charges against you was framed under NDPS.
only NDPS.
Only
my lord.
NDPS.
Yes.
Not the 364.
No.
Naturally, you have claimed to be the kidnapped person. No problem. The co-accused involved in the case along with the said accused person have since been released on bail by the relevant order of the learned trial court of the trial court. It is on the ground of parity that the petitioner has now approached this court seeking similar relief for grant of bail. Mr. Additional Learned AG, appearing for the state respondent, has strongly objected to the submission made and has submitted that this court, in its previous order, when bail was sought for had observed that the accused person in question is involved in the offence alleged, and as such bail was denied. The same situation is persisting, and under the circumstances, the prayer of the petitioner may not be allowed. It is also the submission of the learned AAG that 4 out of 10 witnesses, prosecution witnesses, have been examined, and it is just a matter of a few months that the other witnesses will be examined. The accused person may therefore not be enlarged on bail at this point of time. This court has considered the submission made, and irrespective of the observation made in its earlier order, it is but logical to expect that prima facie observations are made as to the complicity or involvement of the accused, the concerned accused. However, it need not be reminded that eventually it would be a matter of evidence to prove the prosecution case. As far as bail is concerned, it would be an injustice to the accused concerned if he is not released on bail at this stage, since the other co-accused who face the same charges have already been released on bail. Accordingly, on this ground alone, this court is of the opinion that this petition deserves to be considered. Accordingly, the accused person, Contempt, is hereby directed to be enlarged on bail on the following condition: that he shall not abscond or tamper with the witnesses, that he shall appear in court as and when required, that he shall not leave the jurisdiction of the state he is from.
He's from Assam, my lord.
Shall leave the jurisdiction of India without prior permission from the trial court, that he shall bind himself to a personal bond of 50,000 along with one surety of like amount to the satisfaction of the trial court. Petition disposed of.
May I add something, Your Lordship?
Yes. Anything?
Lordship, if Lordship kindly direct that he file the address proof, Your Lordship, before the trial court, Your Lordship. Because my experience, Your Lordship, Lordship is aware that
I think that will be correct. Needless to say, the accused person,
as well as the sureties,
as well as the surety, as well as the bailer, are directed to give their complete particulars as regard place of residence, mobile number, etc.
Lordship, yes. All right.
From the main list, item number 1.
Yes.
My lord, this matter in fact relating to the same Ilaga, one appeal is pending before the Learned Division bench preferred by my friend. So my matter may be taken up after 3 weeks, my lord. The same Ilaga matter.
So any order passed in the division bench would have a bearing on this?
It would be different.
exactly,
Not
Lordship.
exactly.
Not exactly.
Because there's an inquiry going on right now regarding the suspension of the same.
The petitioner here is one of those complainant.
You complaining in the original complaint,
Yes.
not in the second case.
You had what was your grievance?
Here in this case, my lord, in this case, my lord, we lodged a complaint before the district council, and he was placed under suspension, and without informing the complainants, the district council appointed inquiry officer. Inquiry officer conducted an inquiry behind the back of the writ petitioners and submitted the report to the district council. On the basis of the inquiry report, he was reinstated. So here the petitioner has a grievance against two actions. One is the inquiry officer appointed, an inquiry conducted without allowing the petitioner to participate. And second is reinstatement without even giving a report of the inquiry to the petitioners. So these are the issues involved.
Subsequently, he was suspended again.
He was reinstated again.
Reinstated. Now he's
Reinstated, and
now he's in office.
later on,
Another fresh
he
complaint
was
now.
exactly.
That
Yes.
was in 2018-19.
So therefore, today, as of today, my lord,
He's now, as of today, he's suspended.
he is suspended. He is facing the inquiry.
Not on account of your complaint.
Yes,
No,
yes,
no.
yes. Different complaint. Different
Fresh
complaint.
complaint with the same people,
Exactly.
set of people.
Here,
I
petitioner is
think
not
I think this court has made an
Your Lordship,
sufficient-
Lordship has passed that
You're
order.
flogging a dead horse, Mr.
My lord, the issue involved here in the present petition is still survive. Still survive. But only since the appeal is coming up next week.
Matter
I
of
prayed for.
2020.
We want to enjoy both, Your Lordship.
No. Here, the present petitioner is not involved in the second petition.
True.
Second petition. He's not involved.
Both sides of the coin.
It's like adding more whip to what has already been inflicted upon the.
Yes, adding more spice and salt.
Right. On premade by the parties, list this matter up to 3 weeks.
After.
Item number 2.
I didn't see you, sorry.
It's okay. It's okay. May it please your lordship. Lordship, we were supposed to prepare and submit our written submissions, lordship. I'm just about to complete it. I pray for some more time, lordship.
You are for?
I'm for the petitioner, lordship, over here.
Mr. General, you are for?
For the
Oh, you're for the.
this
What
is
is this matter?
that local
Local.
issue. Yes, ma'am.
You are for the local.
Yes, ma'am.
You have filed your.
It's ready, but if my friend is taking time, I'll file along with her.
You will respond to her.
No, it's
No,
ready.
lordship.
Mine is
It's a
ready.
separate
Mine is
state
ready.
submissions
Mine is ready.
altogether.
On premade by the parties, list this matter up to 2 weeks.
Lordship, because my friend has submitted, it's almost ready from her side. 1 week can be given, madam.
I'm praying for 2 weeks' time, lordship.
It's almost
If
ready,
he's in a hurry to file, he can file today, lordship.
No,
because it's already ready.
Apparently, it's almost ready. How long does it
Yes.
take? 2.5 weeks.
So
have been
I'm
taken?
praying for 2 weeks' time,
Two and a
but
half
he's in a hurry
weeks.
to file, lordship. It's very obvious.
No, it's very obvious
Yes,
because
he's
I
in a
do not
hurry.
want the matter to disappear from
Exactly.
Lordship's mind, and this
So
is
let
the
him file,
intention.
Lordship.
You are the petitioner. You should.
Exactly.
he's
so
the
let him
petitioner.
file, lordship. Why is he hurrying me?
he has to
can
file
file
first.
He can file today, lordship. I'm not
But you are-
objecting to that.
I've stated 2 weeks. Let it
Very
be.
Much obliged, lordship.
Item number 3.
My lord, the last occasion, lordship was kind enough to allow me to cure the defect of interpretation in the impugned order. My lord, I'm serving the. My lord, that is the one, my lord. Some mistake was committed in the translation, and that was pointed out by my learned friend, by respondent.
This was the correction of annexure.
My lord, that is the annexure, my lord, 11, page number 206.
Of the impugned order.
Impugned order.
Oh, I think.
Impugned order.
All the respondents are in
My
attendance.
Lord, I'll be appearing for 1, 2, and 3.
Have you filed your counter?
No, not yet, my Lord.
Have you got a copy of the?
Yes, I've received a copy because, my Lord, in the meanwhile, a bill has also been passed by the council in respect of the administration of this particular tendering area. It's awaiting approval from the governor. So perhaps that also will have a bearing.
But that is one aspect of the matter. Only today my humble prayer would be.
Because in that case, then the issue of virus might
come up. But
Because
as of now today,
this dispute has been there for a very, very long time. So the council is trying to streamline by enacting.
Here, I think it's only, if I remember correctly, I have not gone through it. It's only a differentiation between Rangbasno and Sodar, isn't it?
no, my lord, there are 9 localities in the tendering areas, all throughout. And in 2004, there was a complaint addressed to District Council Executive Committee, and the Executive Committee passed an order that to upgrade the localities to status of villages, one has to follow the Ilaga Act, creation of villages. So that was the order. Now the private respondent filed a writ petition before this court in 2008. This honorable court dismissed the writ petition that you are raising disputed question of facts, creation of villages. High Court cannot interfere. They filed a writ appeal again. Writ appeal was dismissed in 2014. So the order passed by District Council Executive Committee in 2004 was not interfered with. Now, after my lord lapsing of years, recently, straight away my private respondents again put up application before the same Executive Committee, and the Executive Committee passed an order for creation. Now that is against the provisions of the Ilaga Act 1991. And the district lordship is aware, District Executive Committee has no review power. So that is the crux of the matter.
So if,
that is a special,
if the act is amended or worded accordingly to include the provision for creation of those villages or whatever.
My lord, nature of the appeal we don't know. But as of today, my lord, as on today,
Yes, as of today,
my lord, my prayer would be, my lordship may pass some status quo order. Otherwise, the third party right would be created. Now, 8 villages has been created as a separate village, in contrary to law. Now, if these 7, 8 villages start alienating the land, that will have a serious repercussion, effect in the nature of the case here. Third party right would be created. That will complicate the matter. So as of today, my lordship may pass an order for maintaining status quo order. So the third party right will not be created. In the meantime, they can file a counter.
What is the situation? What is the situation now?
These are all right lands, actually, all right lands. Of course, I would have no objection for maintaining of status quo. Because alienating, if any of the private persons alienate the land, that may cause problems later on. And of course, my lord, there's also
we are talking about administration of the villages, or what is the issue about?
No, the customary nature is, my lord, the writ petitioner has the right to administer over the land of the entire village. Now, because of the creation of the new village, they may enjoy separate status and they may claim.
Who are you?
I'm the man of the tendering method, the parent village.
No.
He's the Sardar.
Are you the Sardar? You're the Sardar.
I'm the Sardar.
Okay. You're the Sardar.
I'm the Sardar.
If we go by by common knowledge, it means that you are the head of the administration of a certain jurisdiction. Now you wish to extend your jurisdiction to the village concerned village.
Now, all these villages, now the present villages, were only a locality under my administration.
Oh, they are, okay.
Yes. And now, in view of the creation by District Council, each private respondent may claim separate independence and they may start alienating the land. So that is my apprehension.
The entire dispute actually arose because of land compensation. That's how the dispute arose. It's in respect of payment of land compensation. That's why the parties are.
So my miscase is still pending. Therefore, your lordship, please, to pass a status quo order, to maintain status quo by all the parties.
Regarding status quo, just give me 2 weeks time, because the influence order which they are under challenge is only of one village, while in the writ petition they have included all the 7 villages, but they challenge only one order of one village. So all the remaining 6 has
comprises of all the villages.
Influence order.
7 petitions are there. Same petitions,
are there, but
same contents.
Order are there,
same I can bring on record additional one.
Of one village.
7 petition?
Seven localities came up with 7 petitions before district council. I have annexed only one because it is similar. Page number 1 till the end, it is similar. Prayer. It is the same locality. Different locality under my same administration. Therefore, for the sake of my convenience, I did not bring all the petitions. If that is required, I can bring on record. But that cannot be the ground for.
No, you should have done that, Mr.
And the challenge is only of one village, Lordship.
You should have done that,
No,
Mr.
it is all the villages. I
Headings
think.
also is only of one village.
It is all the villages. The impugned order, it has all the villages.
So to see that
Have you you did
Yes.
all those villages as
Yes,
respondents?
yes, sir. They are a party here.
The order and the
They are a
challenge is only
party.
of one village.
Lordship, kindly see the course title.
page 2, my lord.
Yes, page number 2. Now, number 4 to my lord, number 10. These are the new villages, spearheaded by the locality head. They came up before district council, filing similar petitions.
Yes,
They are a party.
but you see, the course of action would be separate and distinct.
It is same application they came up.
Separate.
Separate application, but on the same proceedings.
Separate application,
Yes,
but the impugned order was passed separately.
no separately.
Separately, Your Lordship.
But it is on the same impugned order.
No, Your Lordship.
Is it?
Separate, same impugned order.
It's only of
I'll
one
have to
village.
take instructions on that.
Lordship, kindly see page number 206.
We'll look at your fresh.
New one, the translated one. And Lordship, can you see the ending part?
Yes.
I'll show. My Lordship, can you see paragraph 13? Paragraph 13. Well, the right tendering from the time immemorial includes village locality. Now it is called as tendering, Lumsing Sai, Lumsik. These are all the, my lord, the respondents. So the impugned order cover entire 7 localities.
He done the order?
Your Lordship, and the petitioner here has filed under the word capacity also. Your Lordship, in paragraph 1 of the petition, Your Lordship.
Lordship, if they want to object my minimally, they should have filed the application.
File.
I filed last year, my
Just a
lord.
moment. I think this order has to be qualified, or rather has to be interpreted accordingly, in the right perspective.
Well.
13, because 13, your paragraph 13.3 would indicate that it pertains only to one village, Mokduk.
Magutu and other named applications as per the evidence cannot be denied, my lord. So it covers
My lord, I'll
when
seek
we read together.
instructions on this.
So
in this
para
regard,
3,
whether
2,
there are separate
it
orders or
covers
not.
all. It covers.
Separate orders also. I would like to take your to paragraph 1 of the capacity, which is filing this petition. The petitioner is one of the duly recognized village, namely it's not right. It's not right. It's not right. Right. It's not a village. Tendring is a village.
If my friend wants to raise, let him file affidavit.
Yes, yes.
Orally, I cannot.
File because
let him file affidavit. In the meantime, my lord, status quo may be directed to all the parties to maintain. Otherwise, they may start alienating the land.
No, Your Lordship, because in the
third party right would be created.
Development officer also, separate village have been recognized.
That is why, my lord, they are attempting to alienate the land.
No, the recognition of villages is not in dispute, my lord. Villages are there. But now the only question which has arisen between these the parties is regarding the land compensation, as I said, payment of land compensation. So the question which they'll have to address this court is whether this order is passed under the Ilaka Act, or is this an administrative order by the executive committee, which is under the customary laws.
Your Lordship, what my senior has made a submission regarding the land, Your Lordship, it's there in this paragraph 13, clause 4, Your Lordship. It's not with us, it's not with the village. Operative part is last page, Your Lordship. For the smooth functioning of the administration and custody of the land, the institutional part of the right in consultation with the Bakra of Right Land, they can write or make procedure for administration of custody of the land of the right, and this procedure should be approved by the commander bar of the right and from the same of hearing. It's not with us. It's with the right of non-current.
Take it. He's a pro forma respondent, the chief.
Pro forma respondent from the same of Makharin and Bakau. Now there is a lot of conflict in these villages because when they claim though they say there are villages as known it as localities, but it was not yet approved even by the same of Makharin and Bakau to be full-fledged villages. And then now when they claim the administration, they also most of the time they claim over the land. Side. So it creates lots of problem. And this is the complexity that exists in that.
And my friend is the right authority.
Primarily, it's a title dispute. It would appear.
Therefore, my friend is the right authority to recognize the village.
I have actually he has to be approved.
But if he recognizes my friend's locality as a separate village, that is another issue. But he says that he did not create any villages over these new localities.
It's there in the petition on the Lordship.
There is nothing as such. There is nothing as such.
Lord, I think we have to file our affidavits.
Let them file affidavit, my lord.
At this point of time,
my friend cannot argue in that way.
Now we are only at the stage of filing of your counter. So you file your counter.
Yes.
But regarding the status quo order, I object because
it requires. It requires.
From the block development officer, election is going on for preparing the polling booth and all that.
So status quo order is only in respect of alienating of the land.
Because,
only in respect.
That is only your.
Yes.
So that we can safely.
The order here also is clear, Lordship. It's with the right no crime. It's not with us. Approval of the right no crime. We cannot eliminate a land.
On the merits.
Just give me 2 weeks time to file the counter, Lordship. Then for final.
No alienation of land, my lord, by the other sides.
What status quo, Lordship? I have some objection. Lordship.
Okay, we'll not call it status quo, but this court will direct that in the meantime, the
no alienation
concerned respondent shall not alienate the land in question.
Yes,
sir. But Mr. H.L. Sangrisu, learned senior counsel appearing for the petitioner, has submitted that pursuant to the direction of this court, by order dated. And untuk order dated 12/3/2024, the corrected, translated copy of annexure 11 has now been filed. Accordingly, the said translated copy on being produced before this court is now incorporated in the petition and marked as annexure 11A. I think it should have been 11A because 11 is already there.
Yes. 11A.
In the meantime, the Learned Counsel, Mr. T.T. Dino, Learned, you are the
Special Counsel.
Special Counsel for the respondent KHADC, as well as the respective Learned Counsel for the, as well as the Learned Counsel for the respective, for the other respondent, respectively, has made a prayer that the counter affidavit may be allowed to be filed in due course. Prayer allowed. Another issue that has arisen for consideration is the prayer of the petitioner for status quo in the meantime. However, on the same being objected, this court would consider the same in course of proceedings. Be that as it may, as has been agreed to by the parties, as has been agreed to at the bar, the relevant respondents are directed to ensure that there will be no alienation or title or land, of land or title, as far as their respective localities are concerned. This is not up to
2 weeks.
3 weeks.
Item number 5.
May it please your lordship. That is the departmental proceeding, your lordship.
Oh, the police.
Lordship, yes. Lordship, so last time I have cited a number of citations, your lordship.
So, where were we?
I also have, lordship, so far I have cited non-supply of inquiry report, your lordship. Prejudice has to be pleaded. In this case, your lordship, no such thing has been pleaded, your lordship. What prejudice has been caused? Assuming but not admitting that the report of inquiry has not been submitted, has not been furnished.
Just briefly go back to your earlier submission. What is your objection?
My so far my objection, one, first, your lordship, one is here, your lordship. It is the writ petitioner had admitted to the charges level against him. So in that,
Okay,
in view of the clear admission, your lordship, in view of the clear admission, your lordship, it is even a detailed inquiry also is not necessary, your lordship. It's not necessary, your lordship. Because in this case, your lordship, it is it's not unauthorized leave. Just like that, he just disappeared without being permitted by the authority, your lordship. He didn't apply for leave also. He just disappeared, your lordship. On his own, your lordship, he took leave on his own, your lordship. A police is a member of disciplined force, your lordship. You should know, your lordship. Until and unless you are granted the permission, you cannot remain absent, your lordship. He's a member of a disciplined force, your lordship. And when three notices have been issued, your lordship, he received 2 notices, your lordship. And the first notice he received, he did not join. The second notice, your lordship, he did not join. Only when the third notice was he received, your lordship, then he reported for duty. So accordingly, your lordship, we initiated the departmental proceeding against him, your lordship. We issue him the show cause notice, your lordship, the charges and the statement of allegation. He filed, your lordship, he filed his reply. He admitted, your lordship, to the charges. Even in the course of the departmental proceeding also, your lordship, when his statement was recorded by the inquiry officer, he reiterated, Your Lordship, the same thing. Then, Lordship, they filed this writ petition. They challenged that the report of the inquiry was not supplied, Your Lordship. In fact, Your Lordship, in the writ petition itself, that report of the inquiry had been annexed, had been made part and parcel of the writ petition, Your Lordship. If Lordship kindly come to para 9 of the writ petition, Your Lordship. Para 9, Your Lordship. That has been enclosed, Your Lordship, as Annexion 9. That statement has been made at para 9, Your Lordship. Yes. And, Your Lordship, that report of the inquiry, Your Lordship, will find it at page 26. It is Annexion 9.
Yes.
Lordship, yes. So the contention, Your Lordship, that the report of the inquiry has not been supplied, Your Lordship, that is misplaced. It is a misplaced submission, Your Lordship. It is a misleading submission, Your Lordship.
Yes.
So to that effect, Your Lordship, because the contention has been raised, Your Lordship, that the report of inquiry has not been supplied, Your Lordship, my contention is that, assuming but not admitting, Your Lordship, that the report of inquiry had not been supplied, had not been furnished to the petitioner, Your Lordship, the first and foremost thing, Your Lordship, that the petitioner should canvass his case is that prejudice, Your Lordship. What prejudice has been caused, Your Lordship? No such pleading has been made, Your Lordship, by non-furnishing of the inquiry, Your Lordship. What prejudice has been caused? That is not the case here, Your Lordship. It's just only a big statement, Your Lordship. A big statement that it is well settled, Your Lordship, that the report of the inquiry should be furnished, Your Lordship. Lordship, we dispute that because in para 9 of the writ petition, in Annexion 9, you have enclosed the report of the inquiry. So the contention that the report of inquiry has not been supplied must fail, Your Lordship.
Yes.
Then, Your Lordship, the statement of allegation, the charges and the statement of allegation, Your Lordship, has been. Lordship, kindly come to page 16. Page 16 and 17, Your Lordship. These are the
16, 17 of?
16 of the writ petition, Your Lordship. These are the statement of allegation or the charges, Your Lordship.
This is show cause notice.
Lordship, yes. The charges, Your Lordship. Then, Lordship, can you see, come to page 18, Your Lordship. This is the article of charge,
yes.
The statement of allegation, Your Lordship. And the reply filed by the writ petitioner, Your Lordship, will find it at page 19, but the type copy at page 20, Your Lordship. Lordship, kindly come to page 20, that is the type copy of the reply.
Yes.
Lordship, kindly come to para 1 of the reply.
Yes.
that Madam, as per article charge, I was found sent from general rule with effects also without any leave or permission from the competent authority is true and admitted. Lordship, can you see? True and admitted, Your Lordship. So, to that, Your Lordship, I have cited the judgment, so far non-supply of the inquiry report, Your Lordship. I have cited 2001 SIC SEC 391, Your Lordship.
2000?
Lordship,
this is on non-supply of?
Non-supply of the inquiry. In fact, Your Lordship, we have furnished last time, Your Lordship, during the course of the inquiry, or during the course of the hearing, Your Lordship.
Just give me the citation again.
Lordship, 2001 SIC SEC 392, Your Lordship, at paragraph 12.
Yes.
Then another decision, Your Lordship, is 2008 9 SEC, page 31, Your Lordship. Page 31, paragraph 17, 20, 21, Your Lordship. Lordship, 2008,
yes.
9 SEC, page 31, Your Lordship, paragraph 17, 20, 21. Yes. Then, Lordship, another one is 1998 4 SCC 310. Lordship, that is paragraph
Para?
paragraph no. Lordship, this is a paragraph 12, Your Lordship. Paragraph 12, Your Lordship. Lordship, paragraph 9.
9.
9 and 12, Your Lordship. 9 and 12. Then another one, Your Lordship, is 2005 8 SCC page 264, Your Lordship. Lordship, that is at paragraph 25.
264.
Lordship, yes. 264. Paragraph 25, Your Lordship. Then another one, Your Lordship, is 2006 GLR, Your Lordship, 337, page paragraph.
This 2006 volume?
Lordship, which one, Your Lordship?
The GLR?
GLR, Your Lordship, 2006, volume 3, Your Lordship, GLR, 337, page 337, Your Lordship.
Para?
Lordship, this is paragraph 9, Your Lordship. Paragraph 9, Your Lordship. Then 12, Your Lordship. Then another one, Your Lordship, is 1996 6 SEC 415, Your Lordship.
Para?
Lordship, this is a very small, Lordship, the paragraph 3, Your Lordship. Paragraph 3. Then regarding Lordship, admission of charges, Your Lordship. This, Your Lordship, page 124. Lordship, this is 2008 5 SCC 569, Your Lordship. Para 16, 18, and 19. Then another one, Your Lordship, is 2009 15 SCC 620, Your Lordship.
2009?
2009 15, Your Lordship. Volume 15 SCC 620, Your Lordship. Paragraph 13 and 14, Your Lordship.
Are these all the authorities that you have cited?
Lordship, yes.
Are they relating to only one point?
Lordship, yes.
Then why would you cite so many authorities? How will that help your case?
Lordship, because this is the principle, it reiterates, Your Lordship, that prejudice has to be pleaded, has to be shown, Your Lordship.
If the authorities cited, have discussed, certain angles of the issue involved, then. But if it relates to only one issue, there's no reason for you to cite all these.
Lordship, because these are admission of charge, Your Lordship, admission of charge.
You're talking about the
no, Your Lordship, the earlier one is non-supply of the inquiry, but this one, Your Lordship, 2008 5 SCC 569, Your Lordship.
This is admission.
Admission of charge, Your Lordship, yes.
You should say so.
Then, Lordship, another one, Your Lordship, on the same issue, Your Lordship. 2009,
Yes.
15 SCC 620, Your Lordship, at paragraph 13 and 14.
This is also on admission
of charge, Your Lordship, yes. Then another one, Your Lordship, 1971, Your Lordship, 1971 SCC 1, Your Lordship. 1 SCC 1, Your Lordship.
1.
Lordship, yes. This is Lordship will find at paragraph 4 and 5.
Same.
Admission of charge, Your Lordship, yes. This is also of police, Your Lordship. Yes. Then next, Your Lordship, non-supply of the list of documents, Your Lordship. This, Your Lordship, we are citing, Your Lordship, 2005 to GLR.
Now you're citing only
the non-supply of list of documents, Your Lordship.
Should I think it'll be better. You find your written argument.
Lordship, permit me, Your Lordship. I'll keep the judgment on a point wise, Your Lordship.
Exactly.
I'll do that, Your Lordship.
Subject
better,
wise,
I think that
issue
would
wise.
be better, Your Lordship.
Yeah.
Yes.
So it will not be confused.
Lordship, yes.
Mr. Sheikh?
I'll just give a small rejoinder to
Lordship,
the
because
submission, and after that,
I
on the
understand
same day I'll try to submit by written submit only on bullet points, Lordship.
Yes.
Point wise, Lordship.
We'll keep point wise, Your Lordship. Then so
Only
far
on
the
issue
judgment,
of
Your
law.
Lordship, judgment wise issue, Your Lordship.
This is only
issue
on
wise.
law, Lordship.
On law,
Factual aspects, yes, Lordship. Only on law.
Because factual aspect,
Yes.
that is admitted, Your Lordship. He admitted even the charges, Your Lordship.
Factual aspect, yes.
Lordship. I'll do that, Your
Because my
Lordship.
only submission was
Factual aspect will remain as it is.
Yes,
Now
once
only the law, to support your respective contention.
Yes.
Because
once
their
you
contention is mainly on procedural, Lordship.
once you resorted to take action under a relevant provision of law, you are bound by. You cannot deviate.
So you give your respective
Yes.
thoughts here.
I'll make a small rejoinder along with I'll keep my.
This matter has been, a hearing in this matter is concluded. The learned counsel for the petitioner as well as the learned AAG appearing for the state respondent has submitted that they may be allowed to file brief written synopsis of the argument along with the list of authorities relied upon by the respective parties.
My lord, I like to make a small rejoinder to the submission as well as my written submission, Lordship, on the merited, Lordship.
Orally?
Oral, yes, Lordship.
Then do it now.
Lordship, because my learned senior has cited so many judgments with regard to, I'll just on the same day itself, Lordship. On the same date.
The learned counsel for the petitioner has also submitted that he may, on the next date fix, he may be allowed to respond to the submission made by the learned AAG. As prayed for, this is matter till
After 2 weeks, Your Lordship, if the matter come on 25th, Your Lordship.
2 weeks.
2 weeks, Lordship. Obla, Your Lordship.
Obla.
Item number 8.
Yes, have you received?
No, Your Lordship.
None appears for the petitioner. The affidavit in reply to the additional affidavit filed by the respondent has also not been filed. Accordingly, the petitioner is directed to file the said affidavit in reply within the next date fix. This is matter up to 2 weeks.
Thank you very much, Lordship.
Item number 9.
It's a connected matter, Your Lordship.
Same.
It's a connected matter.
Same order.
Your Lordship, but here, Your Lordship, pleadings have been completed, Your Lordship. There's no requirement of any affidavit.
So I'll release this matter up to 2 weeks.
Much obliged, Lordship.
Item number 10.
Lordship, maybe it's Lordship, I pray this matter maybe come after some time, Lordship. So I have some difficulties today. I have to go with doctor appointment.
No, the only
have
thing,
informed
the only thing is to be confirmed by you.
Yes,
is,
only.
whether the new
There is no
dogma is
dogma.
there or not.
To that aspect, as per the instruction, Lordship, from my side, there is no new dogma.
No, there is.
Certificate is there in my affidavit along with the GT. And he has not filed any rejoinder. He cannot make that
No, because I am not aware which certificate he has given, but there is no new dogma. There is no new dogma.
In fact, the Nokma was appointed before he came to this honorable court.
No.
And he has not filed a rejoinder to it.
Lordship, if that is the case, let them supply the copy which
No, it's
when.
there in the affidavit. There is no question of supplying the copy.
You have not read the affidavit.
No, because there's so many, because they have filed a
Now
lot
you're
of
saying
mistakes.
how many is there?
No,
See.
be specific. Either he has filed or I have filed. You cannot say. You are saying to
No,
both
no,
of us.
private respondent, that's fine. Lordship, I'll go through if required. I pray that I may allowed to file the rejoinder to that effect. Yes, if that is the
You
case.
see, is that at this point of time?
And this matter has travelled 3 courts, my lord. Now this is the 3rd court, my lord.
That is not.
Because if that's the case, if a new Nokma has been appointed, then of course you have to implead him or her, whatever. Now, that fact was brought on record by way of the affidavit. You have not filed your rejoinder.
He should have implemented at that point. And last occasion also, I have pointed out repeatedly that it will be wise for him to complete them.
Lordship, I will file it. I will go to their affidavit. I have gone through, but then I don't find this one. Lordship, this is that affidavit they have filed it on 25 July 2022. Lordship, I may be permitted if required to file the rejoinder. If I have not filed, I will. Because this matter has since been long, I have.
July 22. At this stage,
No, Lordship, because I might have filed it also because the matter is pending for long. That's why I also not aware because there is a miscase counter affidavit.
Stay in the miscase, yes.
No, there is no stay actually. There is because.
Mr. P.T. Sangwa, Learned Counsel for the petitioner, citing personal difficulty, has submitted that he may be accommodated in this matter and that the matter may be heard on the next date 6. In the meantime, it is further submitted that necessary instructions may be submitted that necessary instruction will be sought for to enable the petitioner to take necessary steps.
Lordship.
If so required.
Lordship, the maybe was given liberty just if required to find the affidavit.
Not affidavit.
You do one thing first because you have not read the affidavit.
Yes.
You go through that affidavit and see if you are
Lordship.
required to file a rejoinder or not.
Lordship.
Now you are just saying I will file rejoinder. What if it is not
Only
required?
one submission that from the district council, my lord, we have. If the both parties agree, my lord, that let them do cultivation on their own area, my lord, and not to disturb each other, my lord. Others, they.
What is the? Is there any?
Because now this is season for cultivation.
That matter will decide on the next day.
No, my lord, that cannot be, my lord. Just a minute. What is happening, my lord? Both the parties, the Nokma, their Nokma, and this side private party, my lord, they have issued a patta to various clan members, my lord. Now they are cultivating, my lord, and there is a claim and counter claim after the cultivation is over. Now, in example, I cultivate in my land, and now they will say, no, you cannot cultivate. There is no such order of the court, and they come and destroy. I'm not saying, my lord, which party is destroying because there is a claim and counter claim before the district council, my lord. That is why, my lord, if they are cultivating, what I am submitting, if they are cultivating, my lord, they should not disturb each other.
Is there any status quo order passed?
There is. No, lordship.
Saying that the the parties are restrained to cause any damage to the plantation. But however, my lord, because of the way they have construed this order, they have also filed a miscase in that regard. They are basically not allowing the cultivation itself.
No, Lordship.
Only
The police is creating problem for both the parties. And both the parties, my lord, number of people they are approaching the district council.
Oh, then in that case, you see, if you have filed a miscase, that has been disposed of.
No. My miscase also still pending. His miscase
As far as
also
that cultivation part is concerned.
Yes, both the parties' miscase is still pending.
That miscase will be taken up.
On that next date, Lordship, because
So let it
there
come
are
up-
two
let-
miscases.
For the miscase, my lord. Now, in the main case, he has to study. Yeah, on Monday, let it come up on Monday, my lord.
No,
The
Lordship.
miscase, for the miscase only, my lord. Because we are facing difficulty, my lord. Because both the parties, they have a partner. And now, if in case A is cultivating and getting destroyed a crop, my lord, as a human being, that is not proper, my lord. We have sympathy for both, my lord. Now, it is up to the court to decide, my lord. But, my lord, the cultivation should not be destroyed, my lord, but any of the parties, my lord.
Both the parties are not cultivating because in my miscase also I have enclosed all the photo which they have destroyed. The
that is what
betterment
I
and
just
others.
That is why it would be
Yes.
it would be prudent, see, to
clarify only,
to allow the parties, as Mr. Day has submitted, to cultivate their own
portion of land.
own portion until the issue is finally resolved.
Yes.
Yes.
On such a big land, my lord, and no cultivation is allowed by the police.
That would not be, because now
Only the cultivation is not allowing, the part is only the dispute area, not the entire.
Yes,
No, my lord. That is not a correct position. That has not been clarified. If
There is an order.
Just a minute. What we are facing, my lord, is this, my lord? They are claim and counterclaim, my lord. That if we cultivate, they are destroying. If they are cultivating, so that destruction should not be there, my lord, of anyone, whoever is cultivating.
what he said is correct. See, it would involve only the disputed area.
No, my lord. Beyond the disputed area.
Beyond a disputed area, then
but police is not allowing.
If it is beyond a disputed area, it's nobody's case.
No, my lord. What is happening? The entire arcing, my lord. Now,
Yes, sir.
police is not been in a position to interpret this order, and they are stopping. They are stopping everyone, my lord.
Police
Even his party is also agree with this.
What happened is only that then the order will be will be qualified.
Only clarified. Yes, ma'am.
Only thing is that before passing the order, police have gone to the spot and make an inquiry and verify. Then submit the report, and based on the basis of that, court has passed an order.
So you assist the
We are
court-
not consider.
you assist the court
Lot.
in coming to a correct observation. A necessary order will be passed.
Yes.
Because this, I believe, you see, as far as this particular order is concerned, is with consent of both parties.
Yes,
So
yes.
it's for your own, you see, for your own benefit, respective parties.
The thing is that they are allowed to cultivate their own areas.
Exactly. That
has to be clarified only.
That will have to be
If
clarified.
it is your portion, you
We are
You
also
go on with your
cultivating.
own cultivation in your part of the
Yes.
land, he will do. But that apparently that order was misinterpreted by the police.
by the police.
So we'll clarify that.
That only clarification. Let it come up on Monday. Let him also go through the file, my lord.
As far as the main issue is concerned, that will be decided
Yes, my lord.
in due course.
Yes.
On Monday, I may have some difficulty.
So let it be on
because,
Tuesday, my lord.
on Tuesday next after 1 week, lordship.
Why he is running
No,
away? my
not
lord?
running
And
away.
His people will go. His people will go to district council and shout.
We'll do it
No,
on
no.
We'll do it on Monday.
Monday, my lord.
Why? Because this code may not be there from 10.
Yes, on 8th, my lord. It can be done.
Lordship.
So from 10, I think the whole week after that will be gone.
I don't think he should have an objection to the
No, he'll not have.
No, we have no objection actually because there is some because court has passed an order because it is for the both side only. I'm also not cultivating; they are also not cultivating.
So
the court order says we are not agreed. We are in the sense that we are cultivating our own land. Now there is no problem with that order.
Just now you have made a submission to this court. You are not prepared to be heard because you are not well.
Yes.
But your tone says that you are very, you are very active.
Very active, my lord.
Lordship.
As no, we'll do one thing. I'll list this matter on Monday.
And the miscase can be
But the miscase will be taken up that day.
Yes.
This will
Only
not be
miscase, my lord. The main case you argue, but
List this matter on Monday.
Lordship.
List this matter on 8th.
on 8th. Hello.
Much obliged, Lordship.